Good evening and welcome to the Runnymede Society TRU Chapter Winter Semester event. I am particularly pleased to welcome Mark Mancini, the National Director of the Runnymede Society, and of course our guest speaker for this evening, Professor Bruce Party from Queen's Law. Professor Party's teaching subjects include environmental law, property and torts. His research and scholarship has been in the areas of environmental law and governance, ecosystem management, climate change, civil liability, tort, and property theory, university governance, constitutional and human rights, and the rule of law. He has written a book entitled Ecologic, which I heartily recommend. I have read it thrice, and published articles, columns, and interviews, many of which can be found by searching Bruce Party at law.queensu.ca. Tonight, Professor Party will speak on the Civil War inside the law and the side the law schools are on. Please join me in welcoming Professor Party.
Thank you, Jody. Thank you very much indeed, in fact, for inviting me here. This evening would not have happened without Jody. And in fact, she has set a new bar for classy at Runnymede events and law schools in Canada. From now on, when I get invited to do one, I'm going to ask them what they're serving for dinner. I'd also like to thank Mark for coming. Mark has logged a lot of miles this year. This is his inaugural year as director of the Runnymede Society. He's done a fantastic job. The outfit is doing extremely well, and it is in no small part responsible for allowing real debate and dialogue and conversation to happen at Canadian law schools. So, Mark, thank you very much. Perhaps we should start with a land acknowledgement. The land that we're on is owned by the Four Points Hotel, which is a subsidiary of the Marriott Hotel chain, held in fee simple absolute, and registered under the Land Titles Act of British Columbia. You can let your air out now. If you felt a bit of tension, that's kind of what we're here to talk about. We live in strange times. And as students who go to a Canadian law school, you have strange lives. In fact, we live in a strange country in a way. Here's a little joke. So, a fellow goes to visit a couple of friends of his who have a little boy. Let's call him Tommy. And he asks Tommy what he wants to be. He's about 8 to 10. And he asks Tommy what he wants to be when he grows up. And Tommy says, I want to be Prime Minister so I can help all the homeless people. And so he asks, or suggests to Tommy, offers to Tommy, says, Tommy, you don't have to wait for that. You can come now to my house and rake the leaves, and I'll give you $10. And you can give that $10 to Joe, the homeless guy who lives down your street. And Tommy thinks about that for a minute and says, well, okay, but wouldn't it make more sense if Joe came and raked your leaves and you gave him the money directly? And he says to the little boy, he says, I have good news and bad news. The good news is you're a smart kid. The bad news is you are never going to be Prime Minister. The range of acceptable views, both in Canada and in particular at Canadian law schools, has narrowed. At some, it has slammed shut. So you're in law school to study the system of justice. And the question is, What is that? Now, justice is one of those words. It's like beauty or fairness. I mean, its real content depends upon the eye of the beholder. But if, from the Western liberal democratic tradition, if you live under a system of justice, you live under a system that has the following kinds of characteristics. Number one, the unit, the legal unit that the system deals with is the individual. We have individual responsibility. My grandmother gets involved in a traffic accident, and the victim sues me. The judge is going to say, what's he doing here? I am not legally responsible for what my grandmother did. The idea of individual responsibility. There is the idea of equal application of the law. That is, the same rules and standards apply to everyone, without regard to who you are. Justice is blind, the phrase goes. And that's a very important idea. It means that the law is not supposed to take account of your characteristics. We don't really care whether you're man or woman, black or white, disabled or not. We will treat everybody the same way. If we can't see you, if the blindfold is on, then we can apply the rules in a neutral way. The rights that you have in this system of justice are essentially negative rights, because that's the meaning of liberty. It means that nobody can interfere with you, and in particular, that the state cannot interfere with you. And if everybody leaves you alone, that is the very definition of liberty. And I can go on. There's a long, long list of characteristics that feature in a system of justice in the Western liberal democratic tradition. And you'd think that if you were going to law school, those are the things that you'd be learning about. But it's just as likely that you are learning some of the opposite things. Many of our law schools, quite openly in this country, portray themselves as institutions not of justice, but of social justice. And that is a very different thing. The characteristics of social justice are in many respects exactly the opposite. The legal unit in a world of social justice is the group. The justice system under social justice characterizes you as somebody who belongs to a group, or perhaps more than one. You have this idea of intersectionality. You might be a white or black, disabled or not disabled, gay or straight. Add up the variations, and those are the groups that you belong to. And the logic is this, that your responsibilities and your entitlements depend upon the group affiliations that the decision maker will give to you. In what ways is manifested? Well, in the idea of substantive equality, or equality of outcome. Section 15 of our Charter of Rights suggests that equality is a constitutional right. But of course, that doesn't answer the question, because there's two very different kinds of equality. The first, as I suggested, in a liberal, democratic, Western legal system, is equality of application. Our Supreme Court has said that Section 15 doesn't mean that. It means, indeed, the opposite thing, which is substantive equality, meaning that the section prohibits laws that create unequal burdens upon different groups. That's the thing Section 15 prohibits. So if you take that interpretation literally, it means that you do not in fact have either the right or the expectation that the same rules and standards will be applied to everybody, but instead, if you happen to belong to the right kind of group, which the Social Justice Manifesto will define as being disadvantaged or oppressed or deserving, then you can demand that the laws be rebalanced in your favor. Now you'll note that those two kinds of equality cannot coexist. It has to be one thing or the other. You can't on the one hand say that everybody has the right to have the same rules and standards applied, and then other people have the right to have the rules rebalanced to make up for a disadvantage. You've got to pick one. And the Supreme Court has picked the substantive equality option. In this social justice scheme, it's not negative rights, but positive. A positive right is the right to demand to receive something, a benefit, an action, whether it's welfare or legislation, some kind of rebalancing, to demand action, perhaps on the part of other people, but more often on the part of government. Our charter, at least in my view, and it's a view that is probably not universally shared, I mean definitely not universally shared, but my view is that the charter was intended to and reads as a liberal document. And by liberal, I mean liberal in the original classical sense. A document setting out liberal rights, that is freedom rights, that is negative rights, meaning that the government is not allowed to interfere with you. That reading of the charter has not entirely, not holus bolus, but bit by bit been thrown out. It is in the process of being transformed, in my view, from a liberal document of negative rights into essentially a progressive blueprint by a progressive court whose Chief Justice says it's a progressive court in a progressive country, and whose colleagues maintain that it is their job to be the final arbiter of social policy. In other words, they've taken over the job themselves. They have taken the charter as an invitation, essentially, to change the way the structure of this country works. Before the charter, we had the principle of legislative supremacy. Now we had a constitution. It's a written constitution, so legislative supremacy was never absolute in this country. We have division of powers. We have constitutional principles, no doubt about it. And there were lots of times when the courts would tell a legislature, sorry, you can't do that. Fair enough, when you have a constitution. That's the role. But since the charter, this project has accelerated. And because of the invitation they have found embedded within it, essentially now it is the court that is deciding what's going to happen. If you take a wander through the charter, you can see at how the various sections have been interpreted to reach that result. Section 1. Section 1 is now broad enough to drive a truck through. It really doesn't mean anything other than what the court wants it to mean in a particular case. You could even go so far, and I'm not making this case tonight, but you could go so far as to say, you know, if Section 1 is so broad, it essentially means that we really only have a single section charter. All the other rates exist, but you can always override them if you can get through Section 1, so why don't we just have Section 1? Why don't we just give the court the job of saying, look, just do whatever you think is reasonable. Reasonable and demonstrable. Because that's what we're doing now. How does the wording of the rest of the sections help? So that's my complaint about Section 1. But it doesn't stop there. I mean, just take Section 2B, the freedom of speech. the court has decided that instances of restrictions on speech in Canada that would not have passed muster in the US are perfectly okay. Let me give you one example. Here in BC, in the Human Rights Code, there is Section 7. I'm just going to read you the section. A person must not publish, yada yada yada, any statement, yada yada yada, that indicates discrimination or an intention to discriminate, or is likely to expose a person or a group or a class of persons to hatred or contempt. Now, here's that, first of all, that section has been held to be constitutional. And second, here's the kind of results you get. The BC Human Rights Tribunal held this. Here's the scenario. You have a person who's running for Parliament, and you have another person who doesn't want them to win. The first person happens to be transgender. The second person distributes leaflets saying, this person is a man, not a woman, and don't vote for her. She loses, files a complaint with the tribunal. The tribunal says this, using Section 7. It is okay to say that that you should vote for someone because they're transgender. But it's not okay to say that you shouldn't vote for them because they're transgender. In other words, you can discriminate, that is, tell apart, in a positive way, but you cannot discriminate in the negative direction. Okay? That is not applying the law equally to everybody. And it is severely restricting your speech, even if you don't agree with this particular fellow. The idea that you're not allowed to say, don't vote for him, because I don't think that's right. Let's extrapolate a little bit. Let's extrapolate the logic of that decision. If you extrapolate the logic, it goes like this. You can say, she's an American, but let's just go with me on this. You could say, vote for Hillary because she's a woman. That'd be okay. But you could not say, don't vote for Hillary because she's a woman. Right? Does that make sense? Of course not. If you can say the one thing, you can say the other thing because you're making a distinction. We become uncomfortable with saying what we mean. Let me give you some other characteristics when I get to law schools. And by the way, what I'd like to do is, I won't talk for too much longer, what I'd like to do is get into a conversation with you in the room. We are recording, as Jody mentioned. I hope this will be a place where you will feel free to make comments and ask questions as you feel fit to do so. We are recording, though, so here's what we've done. If you want to speak up, then by all means, that will be great. If you don't want to find yourself on the internet, or at least your voice on the internet, we've put some blank pieces of paper on each table with a pen. Write down what you'd like to say out loud, and I will read it to the room, and then I'll do my best to respond. So, just to finish off this idea of these two ways of thinking that are in opposition to each other. Western justice and social justice, and never the two shall meet. Don't be fooled. Social justice is not a benign idea. It is undermining the principles that you may think are self-evidently true and are bedrock and will always be there. That is not true. They are already eroding. And so those basic assumptions that you're making, even to some people believe, people who have not gone to law school believe, that the law is a bedrock thing that will always be there and protect them from crazy people. But it's not like that, right? Law is a product of culture. and the culture is going nuts. So the law is very much in jeopardy. So just a couple more characteristics. Let's talk about human rights for a minute. Now, human rights are simply a kind of right. They were envisioned originally to liberate, yes? Rights not to be interfered with in the sense that your government couldn't throw you in jail without a trial, they can't torture you, so on and so forth. They prevent the state from interfering with you without due process. That was the original set of human rights. They were universal human rights in the sense that they were all, and they held by everybody, enforceable against the state. That is not the present version of human rights. They've become zero-sum human rights. Yes? So, for example, you've heard probably about Bill C-16, which is the federal bill that amends the Canadian Human Rights Act to add gender identity and expression to the Human Rights Code. Now, that was just the federal version. Provincial versions of the same thing have all been put in place. So you have gender identity and expression inside the Human Rights Code. That in itself is probably not a bad thing. But here's the problem. The Human Rights Commissions have said, and the Ontario one in particular have said, the fact that that is now a prohibited ground of discrimination means that if you do not use the selected pronoun of that person, you are guilty of discrimination. That's zero-sum human rights. By zero-sum, I mean this. You give one person a right, and the existence of that right takes the right of somebody else away. That person has the right to a pronoun, and that person no longer has the freedom of speech. It's zero-sum. And why is that an aberration? Because the idea of rights in a Western legal system is that they are universal and reciprocal. So we all have liberty. Let's put it this way. Somebody comes along and says, I want to be a woman. I want to dress like a woman. I want to call myself a woman. I want to use she. Does that person have the freedom to do that? The answer is, of course, because that person is free. Nobody has the right to interfere with that. But everybody else is free too. And if that person wants to dress as they please or call themselves what they want, everybody else has the freedom to make their own judgments about what they see and to use whatever language they wish to address that person, whether it's he or she or z or it or whatever it happens to be. Those are universal rights. And the alternative, as I say, is the zero-sum game, and that does not end well. So I could go on at length about all these characteristics and how they're in binary pairs in these two systems, and in conflict. And the one that is prevailing today, the victory is not complete. But the one that's prevailing is the social justice. So let's talk about law schools. It's perfectly reasonable for individual professors to have takes and opinions on things. That's really the reason the institution exists, to hire people to have their own independent views, and to teach and to write and to express what those views are. I'm not objecting to that at all. What I do object to is this, that the law schools as institutions would take it upon themselves to adopt a political philosophy. To say, not only do we have some professors who believe in this, we are an institution of social justice. Why? Well, because you've just breached the whole idea of the university and law school enterprise. The whole idea is you're a neutral institution. You hire people with their own views. Those are autonomous, independent academics. Hopefully, with a variety of views. And it is through the expression of that variety of views that the students will hear everything. And because they've heard everything, they'll have to sit down and think, well, Professor X says this, Professor Y says that. I wonder what the answer is. Let's chew it over. Let's figure it out. But that's not what's actually happening. What you have in law schools is a disproportionate weighting of one view Now, don't get me wrong, I'm not saying it's universal, not by any means, but it is heavily weighted. The figure that, I don't have a figure for you for Canadian law schools, but the figure that I have seen, I've seen a few, but one of them is 17 to 1. 17 to 1 is the proportion that Jonathan Haidt quotes as the proportion of so-called liberal professors to conservative professors. I can only take their word for that. I haven't done this study myself. I suspect, and it's only a guess, that the number might be more heavily weighted, worse than that, at Canadian law schools. I don't know. That's a guess. I do know that the number of professors who are willing to openly say, look, I don't agree with social justice. I think it's a bad system. I think it's based upon bad premises. The number of professors at Canadian law schools willing to say that, let's just say it's very, very, very small. And as I say, it is, in my view, it is the job of the institution to stay out of that. Law is political, yes. Law is very political. Now, it doesn't need to be as political as it is. One of the objectives of the Western legal system is to contain the politics, yes? 3 branches of government, yeah? Legislature, executive, judiciary. The separation of powers. The whole idea of the separation of powers is to contain the politics in the system to the legislature. That's where it belongs. They're politicians, they get elected. It's proper for politics to be front and center in the legislature. It is not proper, at least according to a Western vision, to have politics driving both the enforcement and the interpretation of the law. The courts are supposed to be technicians. They're supposed to apply what they're given. And today they've taken on, and admitted to, taking on a role that is far beyond that. And so what you have instead is you have a whole legal system that is imbued with politics all the way through. So yes, law is political. But my case is the law schools should not be. Individual professors, sure. But when the law schools as institutions become political, well, that agenda overwhelms. And you get the social justice view of things reproducing itself and helping to transform the country's legal system from one thing to the other. And you see that now in the bench, in the professions, and in the larger culture. There was a time when people said about universities and law schools, oh, don't worry about them, it's just an ivory tower. I mean, people will graduate and they'll find out that the real world is different. That's not the case anymore. Because enough people over a long period of time have graduated from universities and law schools imbued with this view. And they now occupy many of the powerful positions in society. So those ideas are now at the forefront of our institutions, both legal and otherwise. So there's no containing this in the schools anymore. It's out. And I'm sure, I can only guess what your particular experiences have been at law school so far, but I'd be interested to hear about that and to answer any questions that you might have. So I'll hold it there. Thank you very much. Who, keeping in mind my observations about the camera, anybody want to? I'll give you two choices. You can stand up and give us a question. That's the first choice. Number 2, you can come up here and give us a question with the microphone. Or the third choice is you can write something down and surreptitiously hand it to me so that they don't catch it on the camera.
Sure. So.
Do you want to go up here?
No.
No?
Just that. Nice. Just thinking of what we were talking about earlier, I entered law school and sort of with an idea of law as a profession of public service. I was wondering if you could draw a distinction between law as a profession of public interest versus social justice.
Okay, that's a good question. So in a way, I suppose, no one's put that to me quite this way, but I suppose what I think I'm doing is in the public interest. But it's not in the interest of social justice. But people who are trying to promote social justice also think they're acting in the public interest. The problem with public interest is this, especially when it is used as a legislative test. Public interest is like those other words that I used before. Public interest is like justice, is like fairness, is like beauty. Public interest can mean any damn thing you want. And so if you are a decision maker that's empowered under a statute to make a decision, and your mandate is public interest, that means you can do whatever you want. And the Supreme Court has basically said so. I mean, Trinity Western is a case in which the Law Societies of Ontario and BC decided that Trinity Western University would not, well, they weren't in a position to prohibit them from having a law school. They simply said, well, your graduates won't be able to join the Law Society, and therefore they won't be able to practice. And one of the mandates that the Law Societies had was, in the statute, public interest. The Supreme Court of Canada said, oh well, as long as you have public interest as a mandate, you can basically, as long as it's consistent with what we think the values of the Charter are, then you can go ahead and do what you want. Okay? That undermines the whole idea of having predictable, knowable rights and rules in our law. You just throw out the mandate of public interest and let the statutory decision maker do what they like. I probably wandered away from your question.
No, I really appreciate that. Could I elaborate a little bit?
Sure. Yeah.
So there's certain sections of law, whether it's Indigenous law or say things like law clinics hosted in law schools, which purport to say that they are advancing public interest. Right. What do you think of these areas of law or institutions?
Well, a lot of them are consistent with the dominance and the growth of the administrative state. Yes, the administrative state depends upon an ever-growing administration of decision makers and people to regulate and people to decide how to behave and so on. And so a lot of these areas are thick with people promoting the public interest. Just pick anything. Pick the residential tenancy situation, right? We've taken so much of our decision-making out of courts and out of the hands of private people that you need this big machinery now to make sense of the world. I was reading a piece the other day about contract law. Now, contract law should be simple. Offer acceptance, right? Consideration, way you go. And at the bottom of contract law is supposed to be an idea. And the idea is you can decide for yourself the deals that you make. And as long as you're both on the same page and you agree, then that's a contract. And we will not inquire into the substance of the deal. But that's only now a leftover default position, because in so many areas of contractual activity, there is now a regime saying, no, here's what the contract will include. Here's the form of the contract. Here are the conditions. Here are the limits. You know, residential tenancies or telecom contracts or you name it. So the freedom of contract still exists as an idea, but in practical terms, it has been weeded out and dissolved. Excellent. All right, question one. Why must our system or the Supreme Court of Canada pick one or the other, negative rights or positive rights? Okay, good question. So imagine you have a positive right. That means the right to demand that the state do something. Let's say it's a right to housing. You can go to the court and say, I don't have a house, no place to live. I have a right to housing in the Constitution, it's a positive right, therefore the court must provide it to me. Okay? Here's the rub. Governments don't have resources of their own. They only get resources from other people. So as soon as somebody has a positive right, that requires the government to take stuff from other people. And that means you don't have a negative right to be left alone. It's the same kind of problem as with the non-reciprocation, the zero-sum human rights thing. As soon as you give positive rights in one direction, you are imposing the burden of those rights on other people, because the government's just a conduit for money or other resources from one. It's right. The question is always from Peter to Paul, and the government's just there in the middle. So you should always ask the question this way: should it be a right of Paul to get stuff from Peter? If the answer is yes, then you believe in positive right. Question 2. Not publishing or being able to publish hate speech. Would you say it's okay to publish anti-Semitic propaganda? Okay, there's a couple of terms in there we have to talk about. Propaganda is one. Propaganda suggests falsity. Okay? Let's talk about false news. Here's the problem. As soon as you have it as a requirement that news that you publish must be true, then you have given somebody the power to decide what is true. Let's put this another way. Free speech does not depend upon truth. You can say anything you want. If you want to say, I don't believe in gravity, I just don't believe in it, I don't think it exists, well, we can demonstrate that you're wrong. It doesn't matter. It doesn't mean you're not allowed to say it. It just means that you're wrong. You could express all kinds of other ideas about truths that we accept to be true, that it might be true or not. In other words, it is a mistake to connect free speech and truth. Now, should you be able to say things that are derogatory about groups? And my answer is, of course. Of course you are. Doesn't matter who the group is. Everybody is subject to this. The limitations. Now, don't get me wrong. I'm not saying free speech is absolute. There are, of course, exceptions. Here are 2 of the main exceptions. Number 1 is threats of violence, because you're crossing the line there between speech and action. So if you go to somebody and say, I hate you and I'm going to run you through, now we've got a problem. But if you go on the street corner and say, oh, I don't like those people over there. Okay, so you don't like them. That's not a problem. One of the other major exceptions, of course, is defamation. You can't defame somebody unless you're speaking the truth, and then truth becomes an issue. But, to make the point, speech does not depend upon truth, and the law should not require us all to be nice. That is not a legal test. It's not a good legal standard. And you start to prefer some groups over others. Let's try this. Should you be allowed to say that there is such a thing as white privilege? Of course. Of course you should. It might be true. It might not be true. That's not the test. Do you care if somebody's offended? Of course not. Speech is supposed to have effect. If the test for legal speech is whether it has no effect, then you don't have free speech. If you believe in free speech, except for speech that is hurtful, then you do not believe in free speech. I'll carry on with 3, but perhaps I'll have somebody else have to go first. Yeah.
I'm noticing 2 kind of main ideologies that address what I would consider to be the root of conflict. I'll just use that term.
Okay.
One is the traditional view, basically, that you have free will, and as a person with a rational soul, you can choose between good or ill. And as our law society is kind of built up on that idea, you can hold people responsible based on whether they choose good or ill. And the other idea is that the root of conflict comes from an asymmetry in power and not from a free will choice. Therefore, the solution to that corruption, so to speak, is equality and getting rid of hierarchy. My question to you then is, social justice seems to me to be premised on the idea of an asymmetry in power being the root of conflict in humanity. Conflict in humanity is kind of obvious, like there's obviously issues that people are upset about, which is kind of the impetus for the social justice movement. So I want, basically, if conflict is the issue, where are you at with the free will idea? And also, how does the Western liberal democracy actually work to address the corruption? Would it be like better police, root out the corruption, hold people accountable? Like, what's your approach? Is it corruption, in my opinion, is the problem? Does it come from an asymmetry of power? Does it come from personal choice to do evil? And if so, like, depending on your opinion, how do you deal with it?
Okay. So the free will question is very interesting, right? And it's a question that's been investigated by a whole lot of philosophers, and a lot of it's beyond me. But my take on that is this: it doesn't matter one way or the other. Either there is free will or there's not. Let's consider both those possibilities. If there is free will, then you can hold everybody responsible for what they do. If there is no free will, then there's no free will on the part of anybody. And therefore, nobody is in a position to exercise their free will in deciding what we should all do. So you're still back at the place where the same rules should apply to everybody, whether or not we all have free will or nobody does. In other words, there is no elite with the sensibility to say, all you people have no free will, so we're going to tell you what to do. No. You don't have free will either. So you're no better than the rest of us. You have no more wisdom, no more control, no more insight than everybody else. Why should you be in charge? Elitism is actually part and parcel of this whole game, right? I mean, I was at an environmental conference many years ago. And environmental regulation is a popular place for regulation that instructs people how to behave. And I expressed the view in some context that actually wasn't appropriate. That there should be rules about what you can and cannot do, sure. But the objective of those rules was not to try and influence your behavior and instruct you on how to be good. It was simply a limit, in the same way that murder is a limit, or speeding is a limit. And one of my colleagues, a fellow that I like a great deal, we were talking about it afterwards, and he said to me, with a bit of incredulity, you don't really mean that people should be left alone to work it out themselves about how they should behave. You can't really mean that. You can't be a law professor and think that people don't need guidance on how to live their lives. And I said, that's exactly what I mean. How did we get the ability or the wisdom to tell people how to live their lives? I mean, isn't that the essence of a top-down system of paternalism? And I'm afraid that view is not universally, but widely held. So the second point of the question was,
how do you deal with the corruption? If the issue is like maybe dispossessed, marginalized groups. I mean, the Hells Angels are marginalized, thank God for that. So I'm not just saying, like, just because they're marginalized, it's inherently good or bad. It's like, but there are some groups who, do have a tough go, and we should talk about that. So how does the Western system, if it is the better way, how does it actually deal with that?
Good. So let's confront this problem. That system I described as being in the image of Western liberal democracies doesn't always work. There are lots of instances where the ideals that I described are not achieved. And when you have corruption like that, you need to do something about it. Here's the difference, though, between these two competing ideas. In the Western system, those are the ideals. They're saying, this is the way things are supposed to be. Laws are supposed to be equally applied. The individual is supposed to have individual responsibility, and so on. The other system says, actually, no, that's not even the ideal. The ideal is that we apply laws differently to different groups. Let's confront another problem. In a system where people are free and laws are applied equally, you are never going to get equal outcomes. People who are free are not equal in outcome. And people who are equal in outcome are not free. So we cannot look to equal outcomes as the objective. That's not the symptom of an unjust system. Now, corruption is. Corruption's a different question. Let's go back in time. The system that we want is one in which everybody has the same legal rights. And there were times in history when that was not so. Women, slaves, aboriginals, with respect to all kinds of things, voting, property, and so on. Okay? That's untenable. That's not consistent with the principles of the liberal system. You gotta fix that. And we did. Everybody in this country has the same legal rights. Actually, there are some exceptions. There are some exceptions that you know about, but they travel in the other direction. So that legal problem has been fixed. There are always going to be occasional corruption problems in the way things are administered within the courts or the legislature and so on, and I'm not saying those things are not worth looking out for.
How would you deal with
Well, you'd have
individual
to deal with them, as they come along, to say what's the distance between what's actually happening and the ideal that we have. Right? What shall I do? Shall I go with this one?
Go in order.
Go in order? Shall I go with number 3 here?
Probably.
All right. Okay, probably it is. Not being able to say don't vote for Hillary because she's a woman. What do you have to say about the systemic power imbalance against women in favor of men, and is trying to make things better for a future in which we don't have to think about giving oppressed populations a higher platform to compensate for the past? Because one day, hopefully, things will become fair and equal if we stay on the current progressive path. Okay, well, I think I disagree. Let's put it this way. If this way of thinking is only possible if you agree that people are members of groups. If you are a woman and you have experienced a particular incidence of somebody discriminating against you, well then, do something about it. That's contrary to the law. And that is them interacting with you as an individual. Got no problem with that. What I do have a problem with is saying this: oh, well, you know what? Sometime back in history, the group that you seem to belong to was wrong done by people who look like that guy. And so we're going to give you the job and not him. Okay? Well, that has nothing to do with the two of you. He's not guilty of anything, and you didn't have anything happen to you. Okay? I don't know what systemic means. Systemic, we have, at the Law Society of Ontario, we have a report that says that the profession is systemically racist. Okay? The report on which that allegation is based is crap. It's based upon voluntary responses of a very small proportion of people in the profession. And if you took those results in a different way, you conclude the opposite thing. Whenever you make the claim that something is systemic, you better have some pretty good data to show that everything is wrong and nobody interacts with me in a proper way. If indeed what I've said is right, which is everybody has the same rights, if that is true, then there is no such thing as systemic, whatever the case may be. Doesn't exist. Life is tough for a whole lot of people of all different kinds of descriptions. And it's very easy to assume that the difficulties you are having is because you are a fill in the blank. It's usually not true. It's usually because life is tough. Get on with it.
As a curmudgeonly old guy, a lot of what you say has visceral liberal appeal to me. But as a liberal, I think I'm concerned with your absolutism, and we've had a bit of this discussion privately, but and so let me, as a law professor, try a hypothetical out on.
Okay.
Let's say we have a law professor.
Never heard this happen before between law professors. No.
Yeah, they're well used to me. You have a law professor who's teaching a class that has one black student, female black student, and the law professor refers to this black student as thing and it. Those are the chosen pronouns. that the law professor adopts. And the student comes up and says, I'd really like to be referred to as he or she, or sorry, as she. Those are my preferred pronouns, she and her. And the professor says, to me, you're thinking it, and that's the way I'm going to carry on. Would we really say that the law or the employer, or however you want to put it, the institutions, have no role in behavior modification, as I like to say in torts? Because I don't accept your idea that the law doesn't guide. I mean, behavior modification, deterrence, is all about what criminal law, tort law, and in many senses contract law is all about. So, I mean, how would you propose that that scenario be dealt with?
I don't think behavior modification is the right way to put it. I think that incident is illegal in this sense. I think one of the roles of the professor in the classroom is to be unbiased. In the administrative law sense, you have a person empowered to make academic decisions based upon certain criteria. One of the responsibilities of that person in the classroom is to be neutral with respect to who it is that's giving the exam or making the comments or whatever it is. If you have this scenario that you described, which is that one person is the person I'm going to call thing. Okay, well, that's not fulfilling the responsibility of the role. And as far as I'm concerned, that person could go to the administration and say, yeah, that person has academic freedom, but this is not part of that freedom. That person is deciding that I'm not worthy of being evaluated on the same criteria as everybody else. Going back to the idea of the same rules applying, the same rules and standards apply to everybody. That person now has evidence that you're not doing that for her. And I think if the administration wouldn't do something that you could take, I don't know if a judicial review would work, but in other words, you already have principles in play. You don't need to add new ones to say, oh, well, you know what, pronouns are a thing, and you have to abide by what I want you to do.
So, but even if the student was getting straight A's from that professor, and it's not an honest market, so the professor's favoring the student even, but they want to, I mean, I don't see how it's different from a trans person saying, these are my chosen pronouns, and I find it deeply offensive when you call me something else.
Well, let's try this though. Let's take your scenario out of the classroom and see if, just to see if the classroom context has anything to do with it. Let's take that scenario and put it on the sidewalk, or into some kind of interactive situation that's not in a classroom. And somebody says to you, I want you to call me Zub. And you say, no, I don't know what that means, I'm not doing that. My case is, you don't have to, because you have the liberty to speak, and they have the liberty to decide what they want to be.
I guess the question is really, if that balance would go a different way on the sidewalk is less material to whether you would agree with me that the balance should go the other way in the classroom, and not simply because it indicates that you are going to disadvantage that student otherwise, but simply that you are disadvantaging them by referring to them in a way that is deeply offensive to them.
Well, it's not, my case I'm making is it's not because of the offense. Right? You need to find some juridical reason why the obligations of the professor are different in the classroom than they would be on the sidewalk. If that's because of the obligation to be neutral in an academic way, okay, I can go along with that. But I don't think just because it offends us more in the classroom than on the sidewalk, that's not a good enough reason for me to say, well, therefore, the outcome must be different. There's got to be a good legal reason why we're distinguishing between the one thing and the other thing.
Found our point of departure of
Okay.
see the floor.
Okay, so I have another written one. Goes like this. Relating strictly to law school. I can agree with you that social justice permeates and regulates the law school experience. The regulation, however, of these universities limiting comment to law schools is largely through social shaming or vilifying, as opposed to through legal or regulatory mechanisms. Is this your view of the way in which social justice operates within law school? Okay, let me do that first. Is it simply a matter of social interaction that social justice gets the upper hand? I'm sure that has a lot to do with it. A lot to do with it. There's a lot of, law school has been described as a bit like high school for adults. Yeah, there's cliques, and there's groups, and there's ins, and there's outs, and there's a mob. And these social interactions have a lot to do with how you feel, how free you feel in saying what you think. I don't think that should be policed. It's just social interaction. I don't want to go down their road and say, right, now you can't criticize them for saying that because, no. Free speech for everybody. But it's not just social interactions. It is also the explicit agenda of the law schools. Not every single one, but most of them will have, if you look at all the websites of all the law schools in Canada, you will find on a lot of them a claim that the purpose of the school is to promote social justice. Okay? That's an institutional mandate. And a lot of the rules they put in place and the people they hire are on that page. So, yes, social interactions for sure. And those are things you just have to put up with. But my criticism is about the other categories of things, which is law schools as institutions choosing a side, which I think they should not do. Okay, conditional question. If you do see the regulation as largely socially composed, do you think that the government has the right to enter and I didn't quite get that word. I think enter and basically fix it. This socially acceptable dialogue in institutions. The answer is no. No, I don't think when the bad stuff happens to you, when you don't like their speech, the last thing that you should do is to do the thing that they're saying, which is, you can't say that. You can say that. You can say that, even if we don't like it. That's the whole idea. And it's your job in the social interaction situation to put up with it and carry on. Yeah. I'll take a live question.
Sorry, I think I just realized my cursive is atrocious. On that, so if you can, so say that you can say that universities as public institutions are largely inclined to hire people with a more liberal mindset or a more progressive mindset. Do you think that's their right to select professors whom maybe for publicity reasons, maybe accolades, but is it the right of the administration of a university to choose the people who, and this does go into the student experience, and even if it does lead to a particular political outcome, isn't that their right?
Good question. Good question. Well, let's deal with the easy situation first. The easy situation is, imagine a university that is not public. A private university. Let's take Trinity Western. Okay? A religious institution. Okay? The answer to your question is, sure. They can do whatever they want. They have paying customers, they come in, they make a deal, they have whoever they want to teach, and the student either accepts it or not. No problem. When you're into the other category of institutions, then we do have a problem, because there's disagreement about whether or not they are in fact public or not, right? They get public money. They have statutory mandates. They call themselves public. They act as public institutions in all different kinds of ways. And yet, they still insist that it's their call to make. Well, I'm not sure all that fits together. As you will well know, universities and law schools are all about promoting diversity. All about promoting diversity. But you'd think that the most important kind of diversity in an institution of learning would be viewpoint diversity. That is, diversity of view. So as to allow the students to hear all the sides and be able to work it out. And that, in fact, is not what they mean by diversity at all. Quite the opposite. It's the diversity of appearance and an agreement to philosophy. Conformity. Okay. So, my take on the public universities is it would not be improper to impose upon them some requirements for achieving a diversity of opinion, and in fact insisting upon the existence of some degree of free speech, as they have done, or at least tried to do in Ontario. Okay, can you speak more about indigenous laws and rights? Do you feel that the state is doing too much to accommodate or too little, and why? Okay. My view is that the same rights and laws should apply to everybody. And in order to have it otherwise, you must be treating people as members of groups. I had an argument a long time ago with an indigenous fellow, a positive argument, I don't mean a fighting argument, a constructive discussion, where one of the things he said was, we've been here longer than you. And my question to him was, how old are you? And he said, 35. And I said, well, in that case, I've been here longer than you. Because you're not entitled to tack on all of your lineage, because that's not the way we do things. If it was, all of us would have all kinds of different rights based upon who our ancestors are. I mean, if I could trace something to some kind of lord, does that mean that I have more rights? No, we don't do it that way. According to our esteemed bearded leader, Canadian is a Canadian is a Canadian.
He means you, Claire.
But it turns out not to be true, right? A Canadian is not just a Canadian. It depends upon who your parents are. It is untenable in a liberal system of law for your rights to be different depending upon who your daddy is. And I'm afraid that's the kind of territory we're in with indigenous rights. Note this. All indigenous peoples, as is absolutely appropriate, have all the same legal rights as every other Canadian. To have a job, to own property, to move, to marry who they wish, to divorce, and so on and so forth. And then there's the rest. And that varies, of course, from group to group and person to person and so on. But those are dependent upon belonging to a group. And here's the real problem. If you think about the world today, the globe, in global terms, everybody is a minority. And all of those minorities, especially in countries like this one, are mixing, which is good. If we are not already, we will soon all be mutts. And the idea that that should be prevented, and that some groups should be kept pure, we would find objectionable if it was expressed about the Germans, or the Italians, or the Indians, like the Indian Indians. But when it is expressed about the Aboriginal community, nobody looks at it. Why is that? There's no particular reason why the Aboriginal population should be protected from the same dynamic that is happening to every other single people on Earth. I don't understand the case that's being made. Okay, I'll leave that page and we'll go here.
I guess kind of piggybacking on what you're saying there, the one reason that seems obvious to me is that the relationship wasn't entered as subjects of a law, right? Like there were actually two treaty parties, which leads me to another question I've been wanting to ask for a little while, which is, I wonder, maybe just ask it more neutrally, is like, how would you make sense of what seems to be really clearly a group aspect to Canada as origin for the French and the English?
Okay, so are you asking whether or not we should, I'm not sure what the question is. Well, you believe?
Well, because you said, as I understand it, this group, we're talking about groups,
yes,
as categories of laws incompatible with
yes,
the Western tradition, but in Canada we see a history of more than just the charter, where that's actually been a core part of this.
yes, so let's make this observation. There are parts of our Constitution that entrench the idea of groups. The French-English one is, situation is one. The Aboriginal law is another, right? You can't just wave a wand and say, well, we don't want that idea anymore. You got a real big problem changing the Constitution if you're serious about that. And it is true that the Constitution was a deal. between what was then groups. But I did a dialogue with a professor from Osgood the other day on the rights of Indigenous people, the UN Declaration on the Rights of Indigenous People, and she gave me a scenario. And the scenario was this. Imagine, she said, imagine in Canada, we gave permission for some group of people from somewhere else to come in and do something temporarily, and then they wouldn't leave. And they took over. Wouldn't we be outraged? This is the situation, she said, that Aboriginal peoples are in. Wouldn't we think something should be done about that? And my answer to her was this. It's not a good comparison to pretend like this is happening now. Just take your scenario, take your exact scenario and say, this is what happened 400 years ago. Today, do we care? Are we worried about who was Canadian and who were the newcomers? Whose lineage is related to who? Which people are related to the invaders 400 years ago and which were there already? And which are new immigrants to this new country? None of these questions are relevant. We shouldn't care about any of those things. Here's the question about that new country that came about because of that situation 400 years ago. Here's the question. Do the laws and rights apply to everybody in that country? If the answer is yes, and the country is a democracy, then what are you talking about? Who the hell cares? You have what you have today. And the criteria is everybody equal? And if they are, there's no complaint to make, because the complaint is based upon the purity of a people. And if you're going to go down that road, and it's going to be a really difficult road, because you're going to have to fix all the problems in history. And every single people, every single lineage in history has a problem they want to fix because something was badly done to them. Every single one. So my case is this. You can't be selective about this. Do you take them all on, or you dismiss them all and insist that everybody has the same rights? Before I get you to do a second one, is there anybody who hasn't spoken yet who wants to ask a first question? Okay, I'll come back.
Yeah, I guess more practically, like I appreciate your comments because I found law school to be, well, I found it discouraging the level of ideological conformity that's expected and the narrowing of discourse and acceptable views. But I guess, how do we change that? Is that a societal problem? Is it a legal theory problem where there's, theoretically there's, it's become dominated by specific theories? Is it, like what is it? Is it people self-selecting out of going into academia and therefore the pool of applicants is quite narrow and so the professors, their ideological will be largely, like what is it and how do we go about changing it if it's even possible?
This is the question, right? It's not an easy question, not at all. I don't really know. So how do you, so there's a truism, I don't know who said it first, but it goes like this. Law follows politics, and politics follows culture. If you just focus on the law, you're dead in the water. Because it's not the law itself that's being changed by the law, the politics is changing the law and the culture is changing the politics. So if you really want to get to the core of the problem, you have to fight on the cultural level. And there is in fact a cultural war going on. Yes? Now, you can see that happening in the US. And you can call it a war in the US because there are two sides. I'm not sure you'd be hard pressed to call it a war in Canada. It's more like a capitulation. Because there aren't really two sides. It's just sort of happening. That's one reason why the law is going the way it is. Now how you reverse that? I don't know, one small battle at a time. We had this battle at the Law Society. We had this statement of principles requirement that basically required you to make a statement that said that you agreed with what I consider to be with an ideological litmus test. If you didn't agree with that, then you couldn't practice. So we had a venture election coming up. We tried to recruit candidates to run. We got 22 brave people to do it. They all got elected. And through, to make a long story short, we eventually got rid of that requirement. Now, it's just the tip of the iceberg. There's a whole lot more going on that's exactly down the same line that's not going to be easily fixed. And whether or not this is just a blip on the road to where, or whether it's a sign of something turning around, I really don't know. But there are no easy answers to your question. I wish I knew. Okay, so let's try this one. Nietzsche is often, I'm not sure I'm good on Nietzsche, but let's try it, is often credited with stating that God is dead. But he rarely quoted the latter half of the phrase, which goes, "And never will we find the water to wash the blood from the streets." The idea is that Judeo-Christian values must be replaced, or I can't quite make that word up. If elitism in government nor in activist judiciary is not the solution, what is? If society does not exist as something to be manipulated for the betterment of humankind, what is its purpose? What role, can't quite make that out. I'll stick with what is its purpose. All right, so my answer to this is this. Everybody's purpose is their own. And the purpose of the law is to make you, to allow you to make that choice. As soon as you get into deciding on a collective purpose, you got a problem. Because you've given somebody the power to decide what the purpose is. Remember, the only person inside your head is you. Nobody else knows what goes on in there. And only you know what you want. In other words, desire is subjective. The whole of economics is based upon that idea. There's no such thing as a right or wrong inside your head. It's your head. So as soon as you have somebody else coming along and saying, right, we all have to change course here and try to achieve this. Sorry, that's not on. This idea is basically expressed in the US founding documents, which is why I think they've done so well. It is, though, the basic liberal proposition, which is, don't tell me what to do. As long as I'm not causing harm to somebody else, my purpose is mine to figure out. Now, you can do that in any way you want to. You can join a church, a religion of any kind. You can decide to be hedonistic if you want to. Or as the case may be. As long as you're not interfering with other people, do whatever you like. And that's the purpose of having a society that protects your liberty. Okay, so we're back to, let me try this question here. How can certain groups rationalize defending our system of justice when decisions go their way, but at the same time, those same groups commit acts that violate the very things our system of justice prohibits when judicial decisions go against them? I think in the abstract I agree, but it's hard to go on without a concrete example. So I'm going to give that one back to whoever wrote it and ask them to give me a for instance.
Sure. I wanted to ask you about multiculturalism. So
Okay.
I guess the Canadian state has endorsed multiculturalism as a guiding philosophy of Canada. Is that compatible with a legal system based on freedom? And then secondly, it seems like your argument is that people are sort of ungenerously blank slates, but a lot of people are coming into Canada with very deeply held cultural conditioning, such as, to use an example, like Islamic people have very different ideas of free speech or religious accommodation. How can that be accommodated within the legal system that you endorse?
Okay, I think very easily. I think it gets too complicated unnecessarily. If you stick to the general idea, then everything becomes clear. The general idea is you can do whatever you want as long as you don't interfere with other people, right? So if you come to Canada with strongly held religious beliefs and you can comply with those beliefs on your own without requiring behavior from other people, no problem. If those beliefs require other people to adhere to your speech expectations, that's not going to work. Sorry, that's just not going to work. Sorry, we already have free speech. And the fact that you arrived here and want us not to say X, sorry, that's not the way it works. Is it the same as the pronoun thing? I want you to use my pronoun. Okay, well, maybe if I feel like it, I will. If I don't want to, you can't make me. Essentially. Right? Now, if you're getting groups of people coming together to agree on what their behavior is going to be like or what their beliefs are going to be like, and they all do it together voluntarily, again, no problem. No problem. But as soon as you go outside that group of voluntary people, big problem. Because now you're using coercion. Multiculturalism can mean one of two things, and one of them's good, the other one's not. The good version is this: we don't care who you are. That's good. We're not going to make different rules for you based upon where you're from. That's good. The bad version is, oh, you guys are this, well, we'll give you special this. Or we'll protect you from that. Or, you know, we need to promote this language. No, you don't. Language is organic. If it serves a purpose, it will survive and thrive. If it doesn't, it will die. Languages are not museum pieces. There's no reason to shut them down, but there's no reason to promote them either. It'll just happen. Leave them alone, is my answer.
So, so I think it's a fair statement that any good system of governance has within it the capacity for responsivity. And for example, when the wildfires break out in BC, we divert more resources than we ordinarily would to any one, portion of land. And similarly, when you have, for example, a woman who's coming out of an abuse situation, we place positive limitations on the rights of her partner. We say you cannot come within this boundary, within this space of this human being because of the realities of your situation and your past with that person. So just strictly speaking towards, there are, I think, pretty acute, demonstrable, different distinctions in the quality of life lived by someone who is First Nations in a fairly remote band. And at least we have studies that suggest that their access, the responsibility and their access to justice differs from, as you would see, in the lower mainland materially. So then, in that kind of situation, is it not, I guess, at that point, permissible for the government to step in and to somewhat alter the way in which it treats a certain set of people, just under, I guess, the tome of responsivity, dealing with a certain portion of the population that has an acute and recognizable issue?
Well, it's not clear now whether you're alleging a difference in application of the law or a difference in outcome. If it's the latter, then my answer is no. If you really mean that there's a difference in terms of access to justice in the sense that, they don't actually have the rights that we think they have, well then yes. Because everybody should have the same legal rights. So if this hypothetical person you're talking about is prevented through somebody's coercion from moving or owning property or having children or getting a divorce or whatever the case may be, then that's a problem. And that should be remedied, yes. But if that person has all those rights and just decides to carry on the way they are, even though it's difficult, and lives in a certain place, even though they're allowed to move, well, no, because those are choices. And, yeah.
I think it might be helpful, I guess, to actually adopt like an example, for example.
Okay.
So, in certain communities, women who have gone to the police, for example, to lodge complaints of sexual assault, we have the figures to suggest that if you are First Nations, you may have actually not received any responsibility on the part of the state. And so even though there's no systemic difference in the rights you face, the actual access to those rights creates a material difference in the lives of these people. And in the same way, we don't want to fire anywhere. But if there's a fire in one place, we're going to put more efforts towards ensuring that the general well-being of that place is secure. So I guess what I'm asking is, do you believe it's permissible in that kind of framework for the government to actually really change the rights of the people in the situation, right? Because in the same way the abuser no longer has the right to enter the space of the woman with whom he was in a former relationship.
Well, you said that example, though, is dealing with two particular people with
Yes,
history,
with
right?
history, yeah.
Right. So you're talking about, I think, you're
I'm
talking about...
going back in macro.
Right. So let's observe this about the present state of Aboriginal populations in Canada, which is not great. I mean, some of them are doing very, very well. Some communities are doing great. All of them are not, right? A lot of people have put that down to the terrible governance situation that they're in, partly because of the Indian Act. And a relationship of dependence, which is what it is right now, requires commitment from both parties. I know that commitment is there. I think because it serves the purposes of certain select people. I mean, there is a group of people who do very well under the present situation under which Aboriginal reserves and so on are governed. Those people are both Aboriginal and non-Aboriginal. And even when everybody agrees that the Indian Act is not great, you can't find consensus about getting rid of it and replacing it with something that's much, much better. So there's a lot of corruption in the system of governance. Okay? It's not a solution to that system to say, well, let's spend more money on this. Because that's been done lots and lots of times. And that doesn't work. There is an idea about how systems work in most communities. The idea is this, whether you're talking about water systems or policing, or as the case may be, as a general rule, those systems are financed by the people who live in those communities. The water treatment plants in Guelph are largely, not completely, but largely paid for by the property taxpayers in Guelph. So with the education system, so with the policing. It's not a solution to say, well, it doesn't work, let's just get some money from somewhere else, okay? You've got a governance problem. And in order to fix the governance problems, you've got to fix the governance. And that's painful because there's lots of vested interests in those systems. Until that's fixed, you won't make any progress. Do we have a follow-up on that question I couldn't make sense of? Oh, with the hypothetical? Not yet? Okay. Let me see if I can find another one. I may have covered them all.
I got one.
Okay.
Getting back to the issue of pronouns, and specifically Professor Jones's example.
Yes.
In the example, in the hypothetical that you presented, it occurs to me that it's more of an issue of capacity in that sense. The professor acting in that way, in my way of thinking about it, lacks capacity to be a professor if he's going to engage with somebody that way. So it's not even really necessarily a legal issue. It's a matter of sanity in a sense, right? Which is something that, again, we don't address very much. And, when you talk about issues like gender dysphoria, we're willing to engage people legally, but in a practical way, we're not engaging necessarily with the issues, right? So there's this sort of underlying current
you know, for lack of a better term, insanity that's propelling a lot of these arguments and a lot of these issues that as lawyers, you know, I think there has to be a point where the law determines whether or not, you know, the capacity exists in that situation to even engage with it rationally. So do you have any sort of comments on that?
Well, I don't think I disagree with you about the particular instance you're talking about. But here's the danger. As soon as you get on the road of saying, well, you know what, there's no particular legal wrong that we can identify, but that guy's just out of his mind and so we can't do that. That's inviting a whole lot of trouble,
Yeah,
right? Because somebody's going to say next time, oh, well, that guy, and when I'm teaching my environmental seminar, I say, climate change. And it would be an easy case to make to say, that guy's not fit. If he's denying climate change, then he shouldn't be in the classroom. So, while I might agree with your take on that particular situation, I don't agree with the remedy. I think you need to find some actionable wrong legally to say that can't happen. And I would like to think there is one, but I would like to know what it is.
Yeah.
You can shut me down whenever you've had enough.
Oh, I would never do that.
I think we've got an update to the earlier question.
Oh, okay, good, excellent. Go ahead.
Yeah, I'm somewhat struggling to perhaps try to piece together a few of your arguments, like especially with regards to rights and somewhat I know you're not saying there's absolute rights, but you know, isn't at some level there's always going to be competing rights, like and there has to, in a system that we have, there's going to be competing rights, and you know, and I suppose, you know, like free speech, for example. You earlier said there was no absolute right for free speech, but I guess like at what level and with what framework do we use to balance those competing rights? Because at one point, you know, a right to say, you know, there's going to be a give and there's a take. So how do we balance?
That's a fair question. So it is true that there are occasionally rights that conflict. Defamation and free speech is a good example. My own particular take on defamation is that defamation should not really exist as a cause of action, for that reason. For the reason that free speech should not be dependent upon truth. It would be much better off for everybody, I think, if, imagine this, imagine that defamation was not a cause of action, and if somebody slammed you and said untrue things about you, you couldn't do anything about it. What would happen? Well, here's what would happen. All kinds of people would be saying all kinds of things about all kinds of people, and you would learn that most of them were not true, and you wouldn't care. You'd solve the defamation problem by having no cause of action of defamation. But back to the larger point. These conflicts of rights happen a whole lot less often than we think, than we're told. You may have heard the story that the role of courts is to balance things, to balance rights. Well, often the rights in play don't need to be balanced. It's a matter of figuring out what the right is and what role it takes. For example, let's say you own a bike. You have all the property rights in the bike. You can do whatever you want with the bike. You can destroy it, you can sell it, you can throw it away, you can repair it or paint it or whatever you want. But you can't knock people over riding down the street. That's not a conflict of rights. They're not interfering with your property rights. They just have a right not to be struck. It's not balancing. It's understanding the nature of the one right and the other one. There's no balancing there at all. And I think a lot of the balancing stuff is the balancing language is to hide the fact that the court is now making a discretionary decision and deciding what they think they would like to have happen. Okay? So I'm not denying that there are those situations, but I think they happen less often than we pretend. And I think that that's often a sign that one of those rights maybe shouldn't exist, like defamation. Let me go back to this. Ah, good, okay. Good. So let me read the question again, and we have a particular example. How can certain groups rationalize defending our system of justice when decisions go their way, but at the same time, these same groups commit acts that violate the very things our system of justice prohibits when judicial decisions go against them? The example, rail blockades. What's what? Rail blockades. Sure, well, you're calling out hypocrisy, and that certainly exists. It exists all over the place, right? So, you know, even someone like me who says, well, look, there's a court injunction, and the police should enforce it. And if the police decide not to enforce it, then we don't have the rule of law. And that's what I would say. That's what I did say. That's what I have said about that situation. On the other hand, when the Supreme Court does something that I think is stupid, and I say, well, that shouldn't be the law, I mean that too. I don't mean it shouldn't be enforced because it's the Supreme Court and they said what they've said, but I don't think it's very good law and I don't approve of it. So I'm going to approve of one thing and not of the other. But perhaps I just take a moment to talk about the blockades question and the police. Okay? So a lot of people have said just that, which is the police refusing to enforce the court injunction is either a violation of the rule of law or a valid exercise of discretion. My vote goes to a violation of the rule of law, and here's why. The whole idea of the Western system I'm describing, as I've said, is to try and take the politics out of everywhere but the legislature. The reason for having police discretion is to prevent government officials from trying to lean on them to make political decisions about who to prosecute and who not to prosecute. That kind of discretion is good, because you're insulating that function from political interference. That is not this. This is a court order. The police do not have discretion not to enforce a court order. That's the meaning of a court order. If court orders are not enforced by the police, what do you got? You don't have a country. Or at least you don't have a country that's functional in the rule of law sense. Okay, so the idea that the police should take it upon themselves to make the political calculation as to whether or not a court order should or should not be enforced and when and where is outrageous. Absolutely outrageous. Cannot be approved of, should be condemned. That's my take on that.
We could probably call it, and if anyone wants to make an escape, they can do that. And
Right.
if anyone doesn't want to, maybe
Great.
you should be
Absolutely.
thrilled to
Sure.
stick around.
Yeah.
Okay.
So,
Great.
yes, so thank you so much for coming. It was a really great time. I enjoyed the questions and appreciate it very much. Thanks. And if you feel like sticking around and talking some more, then let's carry on. But take off as you wish. Yeah, go ahead.